Thank you. My name is Mutula Kilonzo Jr., Governor Makueni, but also an advocate of the High Court and Supreme Court of Kenya. We have had a good session here, several sessions. There was a session for the Women's Conference, something about the experiences women are having, particularly on matters gender violence, femicide, and how to put action together to attack what we call now femicide. On the other side, we had a session of the men's conference, young people, how they can do their business, win cases, but at the same time take care of families. We have a phenomenon which we are all addressing, both as junior bar and senior bar, where the young advocates, particularly the young ones, we are losing some of them, and to what will be either depression, challenges of the legal profession, and the pressure that comes with the work that we are doing is affecting a lot of lawyers. And that has become a matter that we need to address. There was a session of the senior counsel bar by the senior counsel. There was another session between the junior bar and the senior bar on very serious matters, including financial reporting. Increasingly, law firms have become avenues for money laundering, and therefore Kenya was actually grey listed, so to speak, for questionable resources coming through advocates' accounts. And therefore the Financial Reporting Council was here to explain to us what that means and how we can ensure that we know our clients so that we conduct due diligence before we collect resources which might end up being resources that are not a process of crime. And there's also was a session in the afternoon on public interest litigation. You know how important it is. A lot of the cases that are now in court on matters concerning governance, matters concerning corruption, are all public interest litigation, which is part and parcel of what we do. We have a concern about whether or not lawyers are being edged out of public interest litigation, but it's also an avenue for young lawyers to showcase their prowess in arguing these matters. In other jurisdictions, just like pro bono cases, public interest litigation has been used as a part of lawyers giving back to the society. Half the time, or even more than half the time, you see that judges do not award costs in public interest litigation. But it's an avenue for lawyers to really defend public matters out there so that the public can have a say on either policies that anti-people, sale like the one of Safaricom or Kenya Pipeline. Those are serious public interest litigations that lawyers must take an interest in. So those are some of the things that have happened today, and we look forward to the session tomorrow. The mental health issue was one of the things we were discussing with amongst ourselves, the senior bar and the junior bar. There's a lot more to discuss. The legal profession has expanded tremendously. The legal work and the pressure amongst ourselves is, of course, has increased, and therefore it's important that we mentor young lawyers. So we, the ones who have been in the bar for a while, have an obligation to continue sitting with the young lawyers to mentor them and encourage them that they cannot make it as quick as they assume. There's a process and they have to grow into the profession. One of the currencies, if possibly the only one, is a good name. And you must build a good name with time, and it takes time to acquire the notoriety that lawyers must get so that you are recognized as a lawyer and who can get good briefs that can progress these young people. Of course, now we have had challenges with AI, and I've had a discussion, in fact, here. Fortunately, even we have plugged in the county in it, and I've met people who are fellows in Harvard, who are developing policies on AI and governance. Why is this important? It has actually come to pass now that without knowing, lawyers have quoted wrong cases or have relied on AI, and AI has misled them to filing cases that are wrong. So we must find a formula, even in the practice of this profession, where we have a strict policy on how, up to what extent, can you use AI. And of importance is that in other jurisdictions or where AI is used, there must be disclosure of the source. But we don't have rules on it. So there must be a deliberate policy to have regulations on AI and disclosures. Otherwise, we might end up with a profession where AI has misled jurisdictions. And you can imagine a case ruled on wrong precedent or non-existent precedent can take a long time to change. One of the cornerstones of the legal profession is what we call precedents. And those precedents are important not just for the profession, but even for the courts. Because where you quote precedent, we have something we call stare decisis. If you quote a jurisdiction or a precedent of a higher court, the lower court is bound to follow it. And therefore it's important that we have discipline in use of AI and disclosures. And looks like technology has moved faster than law. And therefore there's a call upon the Law Society of Kenya to come up with regulations on the use of AI, which can have a force of law, and penalties where the AI is misused. Thank you. We have a robust legislation on fundamental rights. Rights of human life, human dignity, freedom of speech, freedom of association, freedom of assembly, freedom of media. Increasingly, whether it's abductions, etc., use of force, murder you saw the murder of Dr. Mtiso, the right to life, right of association, all these things have been violated, and it is part of the discussions that you are going to have here. And by the time this conference is over, the Law Society will have a resolution on these matters and how those matters will move forward. You know that lawyers have also their issues with the judiciary. That will also find a resolution that will come out of this conference. But we must say, without a doubt, that we cannot go back to the era where the freedoms of Kenyans were left to the discretion of the executive. That era must come to an end. And more importantly is that the executive must understand that the rule of law is paramount in Kenya, and everybody is subject and is not above the law. So the executive must obey court orders. Where an order is issued, for example, stop the construction of a quarantine site in Nanyuki, an order cannot be a suggestion. Because the violence you saw in 2007 began with violation of court orders. Next, people are going to disregard the law and think that the judiciary is an appendage of the executive. Because if the orders of the judiciary cannot be enforced, people cannot believe then that the executive is independent. Thank you.